Good evening, everyone. Thank you so much for joining us. I'm Rebecca Zimmerman with Arkansas Advocates for Children and Families, and we coordinate the Arkansas Kids Count Coalition, which is a membership group of individuals and organizations all across the state of Arkansas dedicated to raising awareness about policy issues impacting kids and families in our state and teaching people how to advocate. And we're really excited this evening to be joined by Dianna Varady, who works with Partners for Inclusive Communities with the University of Arkansas. And she's going to be talking about special education process and advocacy today to help people learn how to create a education plan for your family, or just to learn about the process in general if you're interested. And so I'm going to kick things off to Dianna. Dianna is going to give her presentation, and at the end we'll have Q&A. So thank you all so much for joining us.
Thank you, Rebecca. Can everybody see my screen okay? The slideshow?
Yes.
Good deal. Okay, thank you. I am Dianna Varady, work at Partners. For those of you who don't know who we are at Partners, we're the University Center for Excellence in Developmental Disabilities for the state of Arkansas. We do training, technical assistance, systems advocacy around developmental disabilities. I work on a couple of projects. One of them is the Arkansas Autism Resource and Outreach Center, where we do mostly trainings for professionals and families around autism spectrum disorders. The presentation that I'm doing, or that I'm going to give tonight, is an abbreviated version of a day-long training that we do for families, parents of students who have disabilities, who want more information about special education and the IEP process. So if you're interested in that day-long training, you will have my contact information at the end of the session, and please feel free to contact me. We are beginning to schedule in-person trainings and Zoom trainings for the coming months. Tonight, usually I know Advocates is focused like a laser on policy initiatives, which is great. We rely on Advocates, Arkansas Advocates for Children and Families to do a lot of work getting people up to speed about those policy initiatives and helping us become better advocates in that realm. However, when you're talking about special education services, advocacy really happens mostly at the individual level, and that's because of the way special education services are provided to students. They're provided as individualized supports. And so really, to be an effective advocate for your child, or for your niece or nephew or your friend's child who is a recipient of those services, the best way you can go about doing that is first understanding that process and understanding where those points in time are in that process when you can advocate for something that's important for that student. So just for those of you who aren't familiar with that process at all, those services and supports for students with disabilities are regulated by federal law. IDEA, Individuals with Disabilities Education Improvement Act, was reauthorized in 2004. And all of the state regulations, which we're going to be talking about a little bit moving forward, all of the state regulations, all of the eligibility criteria, everything is reflected in that federal law here in the state regs. For those of you who aren't familiar with the process of putting in place services and supports that are special ed services and supports, it is very different than the medical model. A medical model relies on mostly clinicians and a PCP, primary care physician, in the case of a child, a pediatrician, or some kind of specialist to make a recommendation and then prescribe a treatment, and then that treatment is provided through a community provider. All of those services, if you want them to be covered by insurance or Medicaid, they have to be considered medically necessary. And that medical necessity is determined by a doctor. Doctors are the ones who make determinations about medical necessity. The process we're going to be talking about tonight is completely different. Every decision along the way, from the moment a child is referred all the way until they transition to adulthood and out of those services, all of those decisions are made by that student's IEP team. And that team is made up of the people who kind of surround that student in life. So administrators at the school, teachers at the school, therapists at the school, parents, and others. There are other people who are often brought on board to be a part of that team. Every decision along the way is it's never a unilateral decision. There is shared decision making occurring at every step in this process, which in some ways makes it a really lovely process because it is very empowering for families if they know how to navigate it. Federal law provides for special education services for children age 0 birth all the way through age 21. Those services in Arkansas for children ages 0 to 3 are provided through program at Arkansas Developmental Disabilities Services at Department of Human Services. And for those children, they have, at the end of the day, after they're found eligible and their plan is completed, they have what's called an Individualized Family Service Plan, an IFSP. But that's not what we're talking about tonight. Tonight, we're going to be talking about services for children ages 3 through 21. For those children, they have an IEP, Individualized Education Plan, and all of those services and supports are provided through the Department of Education. I have a nice little animation to demonstrate or emphasize that. You can find all of the information that I'm going to be discussing here tonight on the Arkansas Department of Education website. If you're a parent, even though it can be really overwhelming thinking about doing this, I would encourage you to go to that website and just read some of the documents that are relevant for your individual child. So say, for example, you have a child who is 7 years old and you suspect that he or she could be eligible under the autism category. Pull up that eligibility category, read all of the referral characteristics and everything about it so that you then have a better understanding of what to expect as this process unfolds. The Department of Education doesn't just fund services through local school districts. They also do a lot of other things. They promulgate the regulations like we talked about. They also keep track of how many children in Arkansas are receiving special education services, and then they report that back to the federal government. And then every year, Arkansas, gets a chunk of money based on that child count data. Then the Department of Education distributes those funds to the local school districts to provide those services that are being provided in the school. And they also provide additional services through centralized teams. So, for example, there are some services that aren't really needed very frequently, like maybe a child who needs an assistive communication device. That's not something that you see very often. So they have a specialized group, like a team, a cadre of specialists who are available to come help local school districts when a child needs a device like that. They also are responsible for due process. And what that means is this process we're going to be talking about tonight, and then also a process for resolving disputes and complaints, which we'll talk about a little bit later. There we go. So the process itself just involves mainly these 3 steps. First, the referral, then eligibility determination, and then development of the IEP. The referral only happens once. That first time that a child comes to the attention of a school district. And we're going to talk about that process in a little bit more detail. Then once the referral is made, the team makes a determination about that child's eligibility for services or not, based on the regulations and the requirements. And then if that child is eligible to receive services, the team comes together and develops the IEP. The IEP has to be reviewed once a year by the team. Typically, that's when some major changes are made to the IEP, but it can be reviewed and changes can be made more often than that. Those are called separate programming conferences, and you can have a separate programming conference anytime, but you have to have an annual review at least once every year. That eligibility determination happens the first time, and then every 3 years after that, they have to review that, and all those same evaluations have to be done to make sure that that student still meets the criteria for eligibility. This is a nice little 1-page document that the Department of Education has put out. It is available on their website, and it just takes you through that process from referral all the way to development of the IEP, and it provides you with those time frames, and it's all in one nice little handy dandy sheet. I like this a lot. We include this in all of our packets to parents who are going through our training. On here you see these time frames. I don't know if you can see my pointer, but from referral to referral conference is 21 days, then 60 days until the evaluation program, or 60 days until all of the evals are completed, another 30 days to the programming conference. I'm going to go over this in more detail, don't worry, but what I want you to keep in mind is that these are maximums. Typically, it does not take that long if you add all of these up together and the school district and the team take the maximum allowable amount of time at every step of the way, it would take 111 days, calendar days, from referral to putting the IEP in place. It almost never takes that long. It's usually much quicker because schools don't want a child just, struggling needlessly, and neither do parents. But these are maximum time frames. The other thing you need to keep in mind is that these time frames do not include times when the school calendar is interrupted. So for example, winter break that's coming up, that's going to be a couple of weeks. That 14 days would not count against this time frame. So say for example, you make a referral now, or not now, let's say you make a referral on December the 20th. So yes, 21 calendar days from December the 20th, but you have to add a couple of weeks on to that because you have to account for those days when school was not in session. Once the referral is made, and here's what you need to do in order to make sure that the referral has been received and is going to be considered. That referral, what we recommend is that referral is made in writing. It can be made by anyone who has knowledge of the child. Typically, it is made by the parents, but sometimes it's a teacher who initiates that process, and that's fine. That referral is made to either the school principal or the designee, the person who the principal designates to handle special education referrals. Once that referral is made, then the clock starts ticking, and certain things have to happen within a certain amount of time. Now, we do make the recommendation that families make that referral in writing, not because a conversation doesn't count. Conversation should count, and it is the opinion of the Department of Education that if a parent speaks to someone at the school who, is someone who can do something about it, like the principal or the teacher, and says, I am concerned about my child, I think he or she might need special education services. Can we talk about that? That should count as a referral. However, even though it counts, the parent doesn't have any documentation that they've said that. So it's better to put it in writing to make sure that you have some kind of documentation that you have delivered it to the appropriate person. And that way, there's no dispute about that time frame, about what needs to happen next and when that needs to happen. So if you go back and look at that little one-page calendar for this process, you will see that within 10 days of having received that referral, the school district has to notify the parents that there's going to be a referral conference, and then the conference has to be held within 21 days of that referral. So you make the referral, before 10 days have passed, the parents are notified that there's going to be a referral conference on such and such date and time. If that date and time is not convenient for the parents, particularly if the parents have to work and if they have to take time off from work, they don't have vacation or leave that they could use in order to do that. They're not supposed to have to suffer financially for participating in this process. School districts want to do what they can to make this process accessible for parents. So if that date and time is not good for the parents, then the parents can suggest a different date and time, the idea being that everybody comes together and finds a date and time that will work well for hopefully everyone. At that conference, there have to be at least 3 people, and that is what the law says. You have to have 3 people in the room for a conference. If you have 2 people, it's not a conference, and it technically is not supposed to count. That conference typically doesn't last very long because really there are only a couple of decisions that can be made at that point in time. At that conference, we want to make sure the parents are there. We need at least the child's teacher, the classroom teacher, and usually the designee or the principal will be there as well. You may have other people there, but this is not the big conference. This is just the referral conference. So usually it's just those 3. And what they do is, and what they're supposed to do is discuss the concern that was brought to the attention of the team. And this is your team for this meeting, these 3 people. What was the concern? And decide whether or not to move forward. And look at eligibility for special education services. if there are parents out there on the video conference today, it can be more than 3 people in this meeting, and you certainly can bring someone with you to the meeting. If you are feeling anxious and overwhelmed, I don't know about you, I'm a parent. I think I forgot to say I'm a parent of a student who has a disability. So he's a senior this year. We've had many, many, many IEP meetings. And despite the fact that I have been to what feels like hundreds of IEP meetings, every time it's my kid's IEP meeting, it kind of feels like the weight of the world is on my shoulders. Like everything is riding on this meeting. So I understand that and I empathize with you. And if you really feel that overwhelmed, I would encourage you to bring someone with you. Don't go alone, you know, take a friend, take a colleague from work, just whoever can be there and support you in this process, because it can be overwhelming and you can forget things. It can be a difficult moment. It is okay also for you to record the meeting. I do not suggest that you do that without first telling the other people in the room that you're going to be recording the meeting. But I know several parents who insist on recording every single meeting, and with good reason. You know, they walk out of the room and they forget what someone said. You know, for the people who work for the school district, they can be very caring, very empathetic people. They can have really wonderful intentions, but what they may not feel in the same way the parents feel is this kind of overwhelming sense of dread. So if there are members of the educational community on the call today, please understand that the only reason a parent wants to record that meeting is because it really is overwhelming and they really are terrified that they're going to forget something. So you certainly can record that meeting, parents, if you want to. It may be a good idea. It certainly can't hurt, you know, not to catch anyone in lying, just so that you can remember what's said. At that meeting, there's going to be a decision made by the team, and that team's decision is either going to be, you know what, we don't need to worry. This is not a special education issue, and we don't need to proceed any further. That does happen occasionally. Typically doesn't happen when the parent is the one who makes the referral. Sometimes it happens when someone else has made a referral and then the parents bring some additional information to the table that nobody knew. We used to see that occur quite a bit with students whose home language was not English. And so what the teacher thought was a possible special education issue with a student was actually a need for support because that student was just in the beginning stages of learning English. So that does happen occasionally, but typically what happens at this referral conference is that the team decides that, okay, yes, there's a concern and we need to do some evaluations to find out what's going on, right? Whether or not this student is eligible to receive special education services. The third option that doesn't happen very often, but it does happen occasionally is, yes, there's a concern. And while we're doing all of these evaluations, we're going to put in place a temporary IEP. Now, the way that typically happens is when you have a student who has transferred into the district. They arrive on the district's doorstep and they had an IEP in the previous school district in another state, and that IEP does follow them to some extent, but they still have to do something and put a a temporary IEP in place. So sometimes that happens when there's a child who's engaging in a whole lot of really challenging, severe behaviors. They go ahead and put in place a temporary IEP. So if that decision is we need to do more evaluations, and you have to do those evaluations to establish eligibility, even if there's a temporary IEP in place, that is only going to be good until we have the permanent IEP in place, which should be no more than 90 days from this conference. So we have to do some evaluations to find out which category of eligibility the student is going to fit under. This is the only part of the process that is a little bit hinky for me personally. It makes me a little bit uncomfortable that you need to find a category of eligibility. You know, a part of me wishes that it was a little bit less, because that is kind of a medical model of intervention. But you do have to be able to justify these services under some category of eligibility. So all these evaluations are done to help the team make that determination. And they usually have a pretty good idea before they get started which category of eligibility that student will fall under. And I'm going to show you those categories here in a bit. Those evaluations have to be done by appropriately credentialed professionals. And that means if there's a speech language evaluation, it needs to be done by a speech language pathologist. If there's an IQ test, it needs to be done by a psych examiner, so on and so forth. And they have to complete all of those evaluations within 60 days. And there are going to be some academic evaluations as well. Usually the classroom teacher will do that, or a special education teacher might do that. There may be more developmental evaluations. That kiddo is going to get pulled out of class a lot during this 60 days because they're being evaluated for eligibility. If you want to take a look at all the categories of eligibility, you can find them on this website at the Department of Education, DESE website. Department of Elementary and Secondary Education is what DESE stands for. On there, they have all of those categories of eligibility, including the definition, the referral characteristics, the screenings that need to be done, the required screenings, the optional screenings, the required evaluations, the optional evaluations, how to analyze the results of those evaluations, and then if that student fits under that category of eligibility, what kind of considerations the team should look at when developing the IEP. It's some great information and everybody should take a look at it. Keep in mind that we are not talking about a medical diagnosis. Two completely different things we're talking about here. And as a matter of fact, as you're going to see in the next slides, sometimes there is no need for a medical diagnosis at all for some of these categories of eligibility. This is just a list of those categories of eligibility for children ages 3 to 5. As you can see, most of them do not require a medical diagnosis. Only the ones that have a little star next to them even require any kind of medical or clinical evaluation in order to be eligible under that category. And only one of these requires a medical diagnosis from a physician, and that's traumatic brain injury. All of the others will require some kind of clinical diagnostic evaluation and may require a letter or a statement from the physician, but they don't require like a medical diagnosis to be made before you can move forward with that category of eligibility. It's really important for people to understand that if if a family brings a child to a school and says, I think my child may need special education services because I think he may have autism, then, you know, they're not going to be waiting to get into a medical clinic, which sometimes can take close to, 18 months to get an appointment for an evaluation for autism at a medical clinic, at a developmental medical clinic. This process is different. There's still going to be a bunch of evaluations, but the school personnel are going to be doing those evaluations, and a medical diagnosis by a medical team is not necessary. Here's just a list of categories of eligibility for children ages 5 to 21. It's slightly different, but not a lot different. There are a few, I think 2 more categories on this list. Emotional disturbance is one of the ones that is included on this list. That does have to be diagnosed by a psychologist. And then some of the other, TBI is still on here. It still needs to be diagnosed by a neurologist. Some of these others do need specific clinicians to be involved in this process, but by and large, these categories of eligibility are determined through those multidisciplinary team evaluations within the school. I do want to point out the Arkansas regulations still list, and this may be a reflection of IDEA, I don't know, still list mental retardation as one of the categories of disability. The terminology that's preferred by the disability community is intellectual disability. So parents don't need to get confused if they haven't heard of intellectual disability. It is intellectual disability and this category of mental retardation are one and the same. So once the referral is made and all of the evaluations have been done, everybody sits down to the evaluation programming conference that occurs no later than 90 days after the referral conference. There has to be, again, a minimum of 3 people in the room, but this is a meeting typically where you have a room filled to overflowing because you have all these people who've done all these evaluations, and they have to report out what they found on those evaluations. They can't just drop off a report and then walk out the door. So if you thought the referral conference was overwhelming and anxiety inducing for a parent, this conference would, it nearly did me in when I walked into it the first time. It can be really overwhelming for parents. If you want to record it, you can, and this would be a good one to record. Not unusual for several of those people who are sitting in the room to be excused after they go over their evaluation report, and then a smaller team will consider all of those reports and make a determination on eligibility. As far as eligibility is concerned, basically it is determined by asking 3 questions of the team. First, the first question is there a disability? And what they mean by that is, does the child meet the criteria under the definition of that category of eligibility? I showed you all those categories of eligibility. Each one of those in the Arkansas regulations has a definition and referral characteristics and so on and so forth. And so what the team does is they go over all of the results of the evaluations and they say, would this child fit under this category of eligibility? Or is there another category of eligibility that would be more appropriate for this child? If the answer to that question is yes, the child would fit under such and such eligibility category. Then you move on and ask the next question. The next question is, does the disability have an adverse effect on the child's ability to access and benefit from the general education curriculum? And so there are lots of disabilities that that may not have that effect, or there may be a child who, you know, does have a disability, but they're doing okay in the classroom. They are making friends, they're socializing, they're keeping up academically. There are no complaints from the parents or teachers. And if that's the case, then it's hard to argue there's an adverse effect. However, sometimes what happens is we get to this point in the process and folks are a little bit too narrowly focused on academics and when they're thinking about adverse effects. So you say you may have a child who, you know, you've determined they have a disability, but academically they're doing okay. They're making all A's. You can't stop there. You're supposed to consider more than that. And this comes straight from the federal law. And it says just you have to take a look at other areas of development, like affective, behavioral, those sorts of things, before you say there's no adverse effect. Because you can be a straight A student and still have a disability and have a need for special education services. Then if the answer to that question is also yes, then the next question is there a need for specially designed instruction? In other words, you know, is there going to be a need for additional instruction? And it doesn't have to be academic instruction. It doesn't even have to be about academics at all. It may be that that student needs more support around social skills. And, you know, you don't even think about how important social skills are until you see a kiddo who doesn't, you know, have a firm grasp of social skills trying to navigate a classroom environment. It's really difficult. So that additional specially designed instruction can come from a special education teacher or can come from a speech language pathologist. And if the answer is yes, the student needs that, then you're gold. That means that that student is eligible to receive special education services under this particular category of eligibility. And now it's time to develop the IEP. And I promise I'm going to answer all of your questions when we're done, because I can see people have questions. So before you get started on the IEP, just basically the three elements that are important to the IEP are what the student is entitled to, which is a free, appropriate public education. For my parents out there, get used to using the word appropriate when you're describing what you think is needed for your child. Because I believe it was in our son's kindergarten transition conference to kindergarten, we were told we don't have to provide you with the Cadillac of services. All we have to do is provide what's appropriate. So we got really used to using the word appropriate to describe what we thought was necessary to support our son. The services and support are all driven by the goals of the IEP. And if you don't have good goals, then it's not going to be a great IEP. You can have loads and loads and loads of services written into an IEP, but the goals are really the heart of the IEP. And that's where the rubber meets the road. And the services and supports need to be provided in the least restrictive environment. And least restrictive environment is defined by federal law. And essentially it means the percentage of time that that student is among non-disabled peers. the more amount of time they're with their non-disabled peers in non-segregated settings, the less restrictive that setting is considered to be. This is just a list of the kinds of services that may be provided through an IEP. They're going to have to receive either special education services by a special ed teacher or speech language pathology services by a speech language pathologist in order to have an IEP. That's what that specialized instruction is. But you can also have all of these other related services. And really and truly, I want to encourage folks to think outside the box. It doesn't have to be a service in order for it to be a really great support. Some of the best supports that our son has had have been things that we have put together as part of his IEP that didn't involve an additional service, but it was a critically important support. And it was something that, usually involved his peers, his non-disabled peers, in being involved with him and supporting him along the way. Really and truly, the only limitation when you're thinking about goals and support is your imagination. And I'm not trying to freak people out if there are any school district personnel out there right now. But what I mean by that is sometimes some of the best IEPs don't have a lot of services, a lot of minutes of therapies in there, but they have really great goals and really great innovative supports that are written into the IEP. Again, this is just the definition under IDEA and also reflected in the Arkansas regulations of least restrictive environment. It's really, really important for us to think about how we can support that student among his or her non-disabled peers. There's a whole lot of reasons for that. Number one is that the research supports that. Students who have disabilities tend to have better outcomes when they spend more time with their non-disabled peers and when they're educated alongside those peers. Also, another really important reason we want to try to make sure students with disabilities are included in those mainstream settings to the maximum extent possible is, the people who fought for the civil rights of people with disabilities, those people with disabilities who paved that road for us, didn't do it so that children with disabilities could be segregated all the time in separate classrooms and separate schools. That's not why those people went out and marched on the Capitol and went to all that trouble. So on implementation, so the IEP has to be implemented within 30 days or as soon as possible. Typically, they begin implementing, if not all of it, the majority of it the following week. They put it in place as soon as they possibly can. Most of the time, that's because a lot of those services and supports that are being provided through that IEP are, the teacher is just as happy to get those in place as the student and the parents because they need that support too. Another really important thing to think about when you're thinking about what needs to be in the IEP is, what support do the people who are educating my child need? Do they need additional training? Do they need additional materials? Because they may not be familiar with, how to best educate a student like my child. And so in that moment as a parent, not only can you be a really great advocate for your child, your student, you can also be a really great advocate for your child's teacher, and for other staff at the school who are really eager for this kind of knowledge and help. We all need a little bit of help, right? Typically, what folks will tell you is that an IEP, what has been said until recently by people who worked in positions of authority at school districts and at departments of education. What they would say is that the IEP is not a performance document. And what they mean by that is it's really designed to be a blueprint for how to proceed, but it doesn't guarantee any success. Although that's not to say that they aren't trying, but they have said that in the past, that the IEP was not a performance document, that there was no guarantee that a student was going to make progress, which was always incredibly frustrating to me, because it felt like they were blaming the child for not making progress on goals. However, then in 2017, we had this landmark, and by landmark, I mean turned everything upside down, Supreme Court ruling on Andrew v. Douglas County School District. Chief Justice John Roberts wrote the majority opinion, and essentially what the court said was, yeah, no, actually, parents should expect their child, whether that child has a disability or not, and even if that child has a disability that results in really significant symptoms and needs for support, they should expect their child to make progress. That is a responsibility of the school district. So now there is an increased expectation that a child is going to make progress if that child is supported properly, which provides parents with a little bit more ammunition when they're, pushing a school district to do something either more for their child, additional services and supports, or different for their child. If they can point to the data that shows that show that their child's not making progress, then they can point back to this ruling and say, he should be making progress, and you are responsible for that. So that is sort of an overview of what to expect from referral to putting the IEP in place. I could spend the entire day talking about this, but I don't have the entire day. I'm going to go through some of the frequently asked questions that we hear from families before we stop for questions. There are gonna be occasionally problems that crop up in this process. Sometimes it's just a personality conflict, but other times it's just real disagreements about what needs to occur. So you may have a disagreement with the school district about what needs to be in the IEP. You may have a disagreement about eligibility. The school district may say, nope, this child's not eligible because of A, B, C, and D, and you, the parent, disagree. Those disagreements trigger what's called dispute resolution, and we'll talk a little bit more about that. Not a whole lot, but we'll talk a little bit more about dispute resolution. The other thing that can happen is you put in place this wonder, you develop like the perfect IEP. It has everything in it that you think is appropriate for your child, and then the school doesn't follow it. What do you do? that is a compliance issue, and we'll kind of talk through that here in a second. So I want to plug a program that I think is really, really underutilized in the state of Arkansas to help you with this question of what do I do if I disagree? So for those of you who are not familiar with the Arkansas Special Education Mediation Project, it's a project at the UALR Law School. They have professors and students who come to IEP meetings and help address disputes. So if you disagree about anything at all, at any step of the way in this process, disagree about eligibility, you disagree about what supports need to be in place, what services need to be in place, you disagree about the goals of the IEP, anything that is, you know, a disagreement about that process itself, you can get a lot of help from these folks. So you can request mediation if you just are at an impasse and you're not coming to an agreement and you need to move forward. You can request mediation. The mediation project, it's voluntary, so you have to agree to it, you, the family, and the school district has to agree to it. If either party just doesn't want to participate, then they can't come in and help. But typically everyone agrees to it because, you know, it just doesn't look good to decline that kind of assistance. So what happens is they send in a professor and a couple of law students, and they take copious notes during the meeting, very detailed notes. They stop the meeting every once in a while at a good place, and they read back their notes to make sure that everybody is on the same page. And they do that until everybody comes to an agreement, or until somebody says, I'm out of here, I just can't do this anymore. So in that process, maybe the only bad thing is that the parents can't bring an attorney, but the school district doesn't get to bring an attorney either, because it's not meant to be that kind of an adversarial process. So no attorneys in the room. It's free, it doesn't cost you anything as a parent. It doesn't cost the school district anything either, unless something has changed. You can, if you're a parent or guardian, you can bring an advocate with you, a specially trained advocate from someplace like the Center for Exceptional Families. They have specially trained advocates that they can send with you to a meeting. And that decision isn't final. Everybody could walk out the door with this you know, decision that everyone's agreed upon during mediation, and then the minute you walk out the door, you can change your mind. So it's non-binding. They will also come in and conduct what's called a facilitated IEP before you get to a dispute. I think it's a wonderful, wonderful service. They bring those same people in. They do the same thing. It's virtually the same process, but they're trying to head off a dispute, right? They're just making sure everybody's on the same page, and that there are no misunderstandings. If that's not going to do it, if there's still a dispute after that, or if either party, the parents or the school district, don't want to participate in mediation, then, you know, the parent, the family can request a due process hearing. At that hearing, it's just like going to court. So the family is going to need an attorney that is well-versed in special education law to represent the student and the family. And the school district will send their attorney, and they duke it out in there just like they do in a courtroom. It's held in front of an administrative hearing officer, and that decision, as far as the Department of Education is concerned, that decision is final. What that hearing officer says goes. The only recourse that the school district or the family has after that is to go to court, which is the big bucks and the big time. So that's what you do if you have a dispute. If you just have a school district that's not following the IEP, you know, our advice to families is if you discover that the IEP isn't being followed, your first step would be to contact the designee, the person who's kind of in charge of that whole process at the school, and say, hey, I have a concern that, you know, we have this particular thing that's supposed to happen per the IEP and it's not happening. And I just wanted to talk to you about that. And I do think that's a reasonable first step to take. And then, you know, give the school an opportunity to correct the issue. But don't do that 5, 6, 7, 8. Don't even do that 3 or 4 times. If you know that the school's not following the IEP and you have brought it to their attention, you know, 3 times already, you know, it's time to do a little bit more than work it out, because they're just not following it for whatever reason. So what you do then is you contact the Department of Education. Rick Porter is the Administrator of Dispute Resolution at the Department of Education. You can contact him and you can talk to him directly. He can tell you how to file a complaint with the Department of Education. You do not file a complaint with the local school district, with the local school board even. You know, please don't, as a first step, contact a member of the school board or a legislator. I mean, you can do that, but it really, the way you're supposed to do it is you're supposed to go through the normal process of notifying the Department of Education that there's a compliance issue. And really, what happens typically is someone from the Department of Ed will contact the school district, say, hey, we've been contacted by this parent who says that you're supposed to be doing A, B, C, and D, and you're not. And the school district, you know, will provide them with some documentation. And then the Department of Ed, if it's true, will come back and say, you know, you should have been providing this service, or you should have been following the IEP, and you weren't. Follow the IEP. If it's a whole lot of related services, a whole lot of therapies that have been missed, or direct instruction that has been missed because they weren't following the IEP, then, you know, that could be an expensive compliance issue for the school. But that's you know, it doesn't have to be anything that costly. Sometimes it's just you haven't been following the IEP the way you're supposed to, and you need to do it before they get to some kind of sanction, really serious sanction. If you need more assistance with that kind of advocacy around compliance, and that does happen, I would recommend contacting Disability Rights Arkansas, asking them to open a case and support you in navigating this process. A couple of other questions that come up frequently: what if my child gets in trouble because of behaviors? That does occur. It doesn't just happen to kids who have disabilities, but for those students who have disabilities, there are some procedural safeguards that are in place. Number one, if a student who has a disability, has an IEP, is engaging in a whole lot of severe, challenging behavior, or even just, you know, kind of disruptive, interfering behavior that is not severe, what the school is supposed to do, rather than resort to the usual disciplinary procedures, which typically involve suspension or could involve, in serious cases, expulsion. They're supposed to do what's called a functional assessment of behavior, determine the function of that student's behavior, and then create a positive behavior support plan that is designed to prevent the student from engaging in that behavior. Not enough time to cover that in depth here, but we have all kinds of trainings that we can do to help you better understand that process as well. Before they expel a student, a school district, that student has a right to something called a manifestation determination review. That is conducted by the IEP team, and essentially it's an opportunity for the team to evaluate that student's behavior in light of the student's disability. In other words, what the school is not going to be allowed to do is punish a student for behaviors that are a direct manifestation of the disability. And so what happens is if it's determined by the team that the behaviors were a manifestation of the disability, then that pretty significantly limits the disciplinary measures that the school can take. Very important procedural safeguards for students with disabilities. If you want to know what else you can do to prepare for an IEP meeting, first and foremost, find a buddy, someone to go with you. Do not go to your child's IEP meeting alone, especially not the first one, especially not ones that you know, are really have some, you know, heavy consequences. You can go ahead and request a facilitated IEP, especially if eligibility has already been determined. I think that is an excellent idea, and I recommend that all the time to people. And then you can also just go to the Department of Education's website and review some of their documents, some of their forms, some of their policies and procedures. And I know it doesn't sound like something you would want to do on a Saturday night, but really and truly, it's not that terribly difficult to read and understand. There's not a whole lot of bureaucracies in these policy and regulation documents. And especially if you read through the forms that have to be used to document the IEP, you'll get a sense of what to expect in that meeting. Another big one is this last document, the Your Rights Under IDEA document. They have to provide you with a copy of that at every single meeting. Every single meeting you go to, they're either going to give you a copy of that, or you can sign a form that says, no, thank you. I don't need my 100th copy of Your Rights Under IDEA. I have a stack of them. Thank you very much. So those would be my recommendations.